Let's go to Tanya Iser right now, who has heard every single minute of this impeachment trial. She's joined by her political and legal analyst to give us some insight. Okay, Tanya, when we heard at the very end, those last couple of minutes, you heard the prosecution sort of jump in, and they wanted the judge, Lieutenant Governor Dan Patrick, to sort of intervene there at the very end, feeling that his closing argument was more like a character witness.
Right. Obviously, that indicates how effective what Representative Leach was doing. I mean, here you have a representative from Collin County, thundering in this Senate chamber, calling for the removal of Ken Paxton. And he said, none of us want to be here today. I don't. And so I want to bring in Bud Kennedy and Stephanie Alvarado, both of whom have been also watching this trial. I want to get your reactions. Stephanie, I want to start with you as a legal analyst. What you thought about what you heard from Andrew Murr and Representative Leach?
Well, I think what Teresa said is right. Their approach was completely different. Not as much passion, more methodical, but when you feel like the law is on your side, that's usually in the evidence, that's the theme that you will continue to portray. And so that's why he felt he was going to stand up and he's going to lay out all of the evidence, especially the key evidence, since the senators will be able to take the exhibits back with them. He wanted them to key in on what they feel was the strongest bits of evidence that they have. I love his theme when he first did opening close, when he said that Paxton was elected by 4.2 million, but he was only serving one himself. I mean, I think that that's a theme that he kept going. He talked about all the different exhibits with respect to the house renovations, all the things that benefited him, doing things that he wasn't even allowed to do, as far as like electing a special prosecutor, appointing a special prosecutor. He did to purely benefit his friend, is what the evidence they feel shows. So I think as far as them, I agree with you, them saving Jeff Leach until the end was not by accident. That was completely calculated, and it was the right thing to do, because this is about politics, and it is pitting members of the party against each other.
Absolutely, Bud.
Well, I think the difference in the two arguments, I think in Busby and Murr, was the difference in using buckshot and a sniper rifle. Busby had all these different targets. Murr just went through the articles, ticked through and said, you know this, you know this, you heard this, you heard this, let's hear it again, you heard this, you know this. He went through everything. We got to hear the reference to Austin Kinghorn's testimony, saying the Attorney General's office is Ken Paxton's law offices, and he's the only client. It was as if the people of Texas didn't even exist. He was the witness who didn't even know what the oath was, that he was supposed to swear an oath to the people of Texas. And then when Murr talked about the godless, rudderless morality involved, that has to appeal. I think the senators know how they're going to vote. I said that because they've probably already had their consultants write their statements that are ready to publish. So I don't really think they're going to take very long. I think they're going to go out for a while and look like they're doing a lot of deliberation. But I think they really know what they're planning.
Well, we also saw both sides use different methods of conveying their message in terms of what the House Board of Managers did. They were playing selective clips, and we're going to bring up a picture here in a second that shows what the defense was doing. Was they were putting up pictures throughout. That's one showing Rusty Hardin, and they had some other ones showing Bible verses throughout. That's kind of what the tactic was. How effective, Stephanie, do you think it was, in particular, I want to go with the Board of Managers playing these clips of what witnesses said?
Since they don't have I'm assuming they don't have the benefit of a court reporter, that's pretty common, and it is effective when you're worried about whether people are going to mishear or understand testimony that was given. It's always good to have it exactly read back to the jury, so that they can say, okay, well, that's what the person swore to and said under oath. So that was great strategy-wise. That was wonderful. Lawyers use that every day. The only difference is they use it through the benefit of a court reporter by having them read back the record.
I thought it was extremely effective. And
Con,
go ahead.
I just want to say, I think showing cartoons in the Senate is a little juvenile, and I think that, that some of this was something you might do in a court of law. Some of the behavior by Mr. Busby was something you might do at a normal court, but I don't think it plays well with the 31 senators. And at the end, when he interrupted Leach, I mean, in football they call that icing the kicker. It's just like trying to interrupt and trying to knock him off. You saw how effective he was.
The other thing I noticed was, throughout the defense had used this, there are no coincidences in Austin phrase, but we saw the prosecutors turn that on its head and actually use that against Ken Paxton, recounting no coincidences related to how the renovations were handled, no coincidences related to the hiring of Laura Olson, no coincidences in terms of the way that what happened to the whistleblowers, just up and down the line. I mean, how effective do you think that the way they used that was, Stephanie?
That's very common. It was very effective, and that happens a lot too. That's a risk you take when you use a catchphrase like that for a theme when you're trying a case. You could very well have it turned around and used against you, and good prosecutors will do that. I mean, it's happened to me before. And
Tony Busby's original use of it, his opening statement, was based on a falsehood. He was saying that because Ken Paxton tweeted about Dade Phelan's slurring his words, then right then Dade Phelan said, okay, let's indict, let's impeach Ken Paxton. Well, no, the House had been investigating for 2 months. Even the timeline that day, the committee was already moving on it before Paxton tweeted that. Paxton tweeted that knowing what was coming. So, Busby, everybody in the Senate knows that was baloney.
And then the other thing we heard, and I thought this was effective also, was when Representative Murr quoted from this, talking about what Sam Houston had said, talking about do right and risk consequences, and now is your time to do right. What did you think about that, Bud?
Oh gosh, Sam Houston gets quoted so much by everybody. We forget that he got thrown out as president because he wouldn't go along with secession. So the whole idea of it, Sam Houston's Bible, it's overworked at the Capitol, but it's still effective to the people in the Senate chamber.
Okay. Well, I appreciate you guys joining me. We're going to send it back to Mark and Kara.
Okay, great insight, Tanya and the rest of the team. Thank you for that. As we know that the senators are now headed to closed session, they will be deliberating, and there is no time limit, although we did hear Lieutenant Governor Dan Patrick kind of issue some recommendations, wanted them to go till at least 8 o'clock tonight if they did not have a decision, and he talked about if they have to go into the weekend, Saturday and Sunday as well. Once they're done, they will submit a written vote. The clerk of the court will then read the votes, then announce a tally. Then Dan Patrick, again, who is serving as the judge in this case, he will individually poll the senators, and they'll do that for all 16 of these articles of impeachment.
There are two outcomes. So if he is found guilty, he's immediately removed from office. The House Board of Managers can then move to disqualify him from holding future state office. If that happens, each side will get 15 minutes to debate. Then senators will vote. A 2/3 threshold must be met for Paxton to be barred from future state office. If he is acquitted on all articles, Paxton can return to his office.
Of course, we are sitting here waiting to find out what happens, and we will get back in when the votes are being counted. So definitely keep it here on WFAA. We have no idea how long this will take, if we're talking 1 hour or 20 hours.
Well, you can make sure that you can watch Tanya Iser, our investigative reporter, and our team of experts on our streaming app, WFAA Plus, on Apple TV, Roku, and Amazon Fire. If you are at work, on the go, you can always tune in on our YouTube page and at WFAA.com. Right now, we'll send it back to GMA3.
Okay, folks, we are back. We've been kind of doing double duty, both on the live stream and live on TV, so we can kind of settle into a more relaxed format. I want to just kind of get reactions from you guys. I mean, I personally, during Representative Leach and Representative Murr's closings, I had goosebumps at a couple of points. I mean, I thought it was so powerful.
Well, I said the other day that I didn't think the prosecution was bringing all the energy and emotion that they brought in the House when the House passed impeachment with 60 Republicans voting for it. I think they did rally some of that again in this closing. And I think Representative Murr, with his folksy West Texas junction, it was kind of a duel of I'm just a country lawyer, but you could tell who was really a country lawyer. And I thought that his delivery was very deliberate and direct and believable. And you know, Tony Busby is worth every penny. There's no question about it. He puts on a show, he puts on a spectacle, he puts doubt in everybody's mind. But you know, I'm not sure that he was able to push his client over the top. I still think it's one vote difference. I think it's 20-10 or 21-9, and we'll see.
And we will. I think it's likely that we'll see that today, one way or the other. Stephanie?
Yeah, I thought both sides did a great job. I mean, we knew stylistically it was going to be very different because they are such different types of lawyers. Tony Busby, dynamic. I was telling you, Tanya, several times, an hour for a lawyer to argue is a lawyer's dream. I mean, we normally, anybody can tell you in state court we don't get that time. In federal court, I'm sure they get even less time. So it was probably a dream for him to be able to argue that long. So he was going to give it all that he got. He put in there, I don't think it was any accident that he mentioned several times he was a former Marine.
6 times.
Yeah, he knows who he's talking to. He knows that, there are people, there are veterans out there. Those are the people who vote, conservative people. He wants to bring a chord with those people, strike a chord with them, let them know that, he's one of them. A few people were wondering, and I know we talked off camera about why the Attorney General is actually there, like physically there. I also think that was a good move on his part as well, on the defense team's part. Personalize your client, show that he's proud to be there. He's proud to be defended by these 2 fine attorneys. That he's wanting to everybody to see that, yes, I'm here. I want these people that are gonna have to vote against me to look me in the eye and tell me that this is what's happening.
Do you think it was good for Busby to only leave Dan Cogdell a couple of minutes? Dan Cogdell was barely up long enough to say this was dumber than a bucket of hair.
Yeah, I kind of wondered what the strategy of that is. Dan is a big hired gun as well, good lawyer, represented people in complex litigation, white collar crimes, things like that. I don't know. I kind of wondered what his strategy was with that too. Just a different stylistically. Maybe Tony was thinking, Mr. Busby was thinking, hey, if I turn some people off, let's get somebody like you who's a little bit more low key, who might appeal.
Good cop, bad cop.
Yeah, good cop, bad cop thing. Kind of different ends of the spectrum. So good compliments to each other.
I thought Cogdell even felt like he was a little short of it. Obviously, he was brought up to kind of soften the blow. We need to mention, for those who don't know, Tony Busby is a candidate for Houston City Council, and so he certainly used this time effectively to remind everybody about his working class upbringing, his Marine background. Did he mention that he's an Aggie?
He did mention that.
I think he did.
Yeah, he did.
Well, he's a son of a butcher.
That's
Busby, son of a butcher,
right.
Son of a cafeteria worker,
right.
And of course a captain in the Marine Corps.
Right, and he didn't say, and a candidate for your city council is the part he left out.
And he ended by saying, I'm asking you to put this man back to work and vote not guilty.
Right.
But he definitely framed it as they didn't prove anything, nothing to see here, and this is all a conspiracy. I mean, that's kind of the bottom line of what he was saying.
Well, right. And one of the key things there is that he referred to Biden's FBI and Department of Justice, and then Murr came right back and said that when the whistleblowers quit, they reported it to the Trump FBI, and he made a point to say that it was the Trump FBI. They didn't go to the Democrats in Washington; it was the Republicans.
And Stephanie, you have been a special prosecutor, right?
Yes, ma'am.
To be a special prosecutor, you have to be appointed, right?
Yes.
So Mr. Kamek was never appointed, and you would have to be appointed by the DA's office, right?
That's right.
So there'd be a piece of paper if he was. There'd be some record of that.
Some evidence of that, correct?
And that never happened. And contrary to what they played a clip from a hearing either in the Texas Senate or the Texas House, I forget which one, where that claim was made, but that was not the case. He was never appointed to be a special prosecutor, although he presented himself as one. But it was interesting, they described getting grand jury subpoenas as a prosecutorial act. Walk us through the problem with Brandon Kamek getting those subpoenas. What's the issue there?
Well, obviously, when you start to do things like that, you are invading the purview and the province of the prosecuting authority in the county where you're trying to conduct this criminal investigation. The other problem is if you, as a lawyer, as the special prosecutor, are going to be the one doing that, and in any way are thinking about going out on service of that subpoena or talking to witnesses, you are in fact putting yourself in jeopardy of making yourself a fact witness to whatever it is that you may find out. So as lawyers, we're taught, let your investigator do that. That is not, stay in your lane, for lack of a better phrase. Let your investigator do that. That way, if somebody has to testify about anything that happened on that fact-finding mission, they'll be able to do that. You as a lawyer, if you do that, then there you are, you're excluded from working on your case because now you're a fact witness.
And just constitutionally, I mean, the senators know, they write laws about this all the time. The district attorneys investigate crimes. The state attorney general, this is different from the U.S. attorney general. The state attorney general is predominantly a civil law firm. Their job is to be the litigator for Texas state agencies. Only district attorneys can originate a criminal prosecution. They can call in the state attorney general's office for help on a case, but the state attorney general can only originate a prosecution in a few limited cases. So if you have somebody going out investigating who's going down the road to prosecuting somebody, that's not even something the attorney general can do.
Well, no, it's not, and I think that it is these grand jury subpoenas that get us here. The foreclosure stuff, the open record stuff, all the other stuff, they were upset about it, but it doesn't get these whistleblowers to take that step to go to the FBI. That's what does it, because at that point you have stepped into the province of prosecution.
Right.
That's where it's going to get really problematic. And so, but I want to talk about the invoice, Bud. So the whistleblowers go to the FBI on September 30th, 2020, and they're prompted by primarily by the grand jury subpoenas, and then the records show, the metadata shows, well, the records show that Ken Paxton pays for the renovations on September 30th, 2020.
Which did not include any granite countertops, which nobody ever says it did. There was a discussion, but they nixed the granite countertops.
And then the invoice, which is dated September 1, 2020, is created October 1, 2020, and it by Cupertino Builders, and they said it never was sent to Ken Paxton, which is interesting. I didn't realize that. How powerful do you think the invoices are?
Well, there were a lot of questions from readers about, what about these two invoices? How do you who's telling the truth here? I say, well, I think the metadata is what you trust. The metadata shows, October 1st, regardless of what any other date shows. The fact that suddenly the home repairs are paid off the day after these questions are raised falls under the category that we're now labeling as...
There are no coincidences in Austin?
Keep Austin coincidental.
Well, I have had renovations done to my house. And whenever I had my renovations done, my person that did the renovation gave me a list of what they wanted to do. They gave me an invoice, and I had to pay for half of it up front before they ever started the work. And then when they concluded it, I had to pay for that. There was no lag time, and there was no delay in creation of invoices. I mean, it was all very straightforward. And I think a lot of us have had renovations done, right? So we kind of know how this goes. So I guess you just wonder how ultimately that will play with these Senate jurors.
Well, I mean, I think that they're people just like the rest of us. They've had these experiences before, and they're going to use their common sense. That's something that we argue to jurors all the time too. It's like, use your common sense when you're evaluating the credibility of these witnesses, their believability. You're not expected to leave your common sense at the door. And as Bud has pointed out, a lot of these senators are lawyers. So they're not our typical lay juror. They are exposed to a lot of things. They have more knowledge than the average juror, most of them probably. and they're going to be able to separate the wheat from the chaff.
Okay, Bud, I'm going to give you the final word before we take a break and go have lunch.
I think from a political viewpoint, they had to give the senators enough ground to stand on when they go back to their districts. Either 20 or 21 senators will vote to remove the Attorney General. I don't know whether it's 20 or 21, but they'll have to go back home and face this barrage of Trump patriot attacks, primarily from what used to be the Ron Paul faction in Texas politics, which is now the Trump patriot faction that is financing a lot of online comments and paying people to post things. They have to go back, but most of them are incumbents. They have the power of the incumbency. They have some big campaign, banks of money. They are able to stand their ground. I think that Murr gave them enough details to hang their hat on and a few sound clips that they can play if somebody wants to hear it. I think that Murr gave them enough to argue their case. They have to answer the challenge of, well, they didn't have any evidence. And the senators are going to have to say, well, they really did have evidence, and let me show you what it was. And I think they got there.
All right, well, we'll see. All right, folks, we're going to take a break, and Jay says he has a plan for how we're going to, I think he's going to play clips. That's what I'm going to promise y'all from the trial while we wait